A revised settlement in the NCAA Antitrust case was filed late Monday night, and it notably maintains the original plan for new roster limits beginning July 1st. Despite U.S. District Judge Claudia Wilkins' suggestion to potentially grandfather current athletes to preserve their roster spots, the filing confirms that after discussions with member schools, no viable path was found to implement such a measure without creating significant disruption. The updated filing aims to address key concerns raised during last week's final approval hearing. Among those are the rights of future student athletes during the settlement's 10-year span and the difficulties some current athletes have had with the claims process. To ease the latter, the claims deadline has been extended to May 16th, and the attorneys managing the $2.8 billion damages pool say they will continue working with athletes to ensure all claims are properly handled. The settlement, which covers around 390,000 current and former Division I athletes, has drawn relatively few formal objections or opt-outs, something the plaintiffs highlight as a sign of widespread support. They argue that the agreement, which includes a direct path for schools to compensate athletes for use of name, image, and likeness, NIL, is a step toward a less restricted and fairer college sports system. While the settlement includes roster limits that could cost walk-on athletes their places, it also ends scholarship caps, allowing more student athletes to potentially receive financial aid. Objectors argue this change disproportionately affects non-scholarship players, some of whom have already been told they're losing their spots. But the settlement's backers stress that roster limits are part of the broader push for competitive balance and manageable team operations, citing legal precedent that supports such regulation. Another critical update addresses Judge Wilkins' concerns about how future athletes will be treated. The revised agreement clarifies that these individuals will retain their right to seek damages and can challenge the terms before being bound by the settlement. They'll have 60 days after receiving notice to object, a measure that the parties say ensures unprecedented protection for athletes not yet enrolled. A minor portion of the filing also clarifies the college football playoff's role in the settlement in response to earlier objections. The next step comes Tuesday night, when objectors have until midnight to file their responses, setting up the possibility of a final ruling in the coming weeks.